This isn't your average sentencing hearing. This is a pressure-cooked drama with legal stakes up to 20 years, and at the center, a woman pushed to her breaking point. But is she a victim or a vigilante? Let's watch this story unfold.
Guilty to aggravated assault, a second-degree felony, and a pre-sentence report has been prepared. Have the parties had an opportunity to review it, and are there any corrections or changes to it?
Judge, I've received and reviewed it, and we don't have any changes from the first judge.
And state.
Same, Your Honor.
All right, it will be made part of the record for all purposes. And the agreement here is a cap of 10 years imprisonment. So we are looking at two options on the second-degree felony. No less than 2 nor more than 10 years confinement in prison. Also, the defendant could be placed on deferred or unadjudicated probation.
Yes,
I don't believe regular probation is an option under law because of the circumstances of this case. All right. Mr. Lewis, you may go forward.
Judge, this situation, fortunately, it wasn't worse than what it was. Definitely. But it was a situation where my client has been dealing with some harassment and bullying, dealing with the complainant, her friends for a long time at this period. This confrontation here is pretty much her breaking point at that moment. It was totally out of character for her, not something that, in normal, regular circumstances, she would have acted in that way in any way. It was a situation where, and when I say prior bullying and harassing information, I'm talking about from people coming, breaking or shooting in the windows at her home to, very severe or serious circumstances, and that these things have been going on, and actually have been even still dealing with some of it after this case happened, while she's been on bond, to the point of people associated with the complainant or either screen recording or whatever, sometimes docket, and would post these things on social media in an effort to taunt her while this case has been going on. And there was even a situation where she's had people try to confront her. Now, I will say my client and her actions since then, she's done everything she can on her end to try to avoid these situations at all costs. She had moved to a new location that is a safe place for her and her child, that's undisclosed as far as she knows, as far as people associated with the complainant.
What do you think? Is this just retaliation disguised as fear? Or was this a cry for help from someone being harassed and hunted? Drop your take in the comments. Is prior bullying enough to justify violence?
She haven't had any issues while she's on bond as far as attending court or doing anything of that nature, other than I believe she had one situation where when she was in the hospital having a child, she had to miss court, but they had medical issues at that time. She has a 4-month-old child this time to raise and take care of. And as you see in the PSI, she has, until the pregnancy, maintained a stable work history, as well as going to school to help try to further her career. So she is making positive changes for herself, or I won't even say changes, staying on that same track. So I believe her future is one that's definitely salvageable in this circumstance. I think there's plenty of vehicles available through the probation department that could help Ms. Mooney as far as move forward, as well as still be able to serve out any punishment or sentence that court deems necessary. I know there's restitution involved in this case that my client, through with her schooling and her career moving forward, I think she'll be able to take care of that and do what she can to make the complainant whole in that circumstance. There are other conditions, of course, that's available to the court, as well as county jail time or anything of that nature to satisfy any concern the court may have of her actually serving some time in jail if necessary. And I know, as far as her version of it, she talks about, concerning the car running her over or running them over. If the evidence doesn't totally support that, but of course, what she may have been thinking of going through some of her friends, at that time could have been it, but maybe not enough to rise to the self-defense claim that she could have maybe used that trial, liable to use that trial. So we are asking that the court seriously consider placing her.
Now we shift gears from chaos to comeback. The defense is building a case for redemption. New home, new baby, new life. But does a clean present erase a bloody past? The court will have to weigh that heavily.
On deferred adjudication, I think she's the type of candidate that will be able to make the most of that circumstance and will be able to be successful and move forward. Also, I would like to, she did want me to let the court know she wanted the opportunity to address the court and let you know how she would, her plans for the future, as well as her being able to be, how she feels for it being able to be successful on the deferred judge.
Yeah.
I just want to let the court know that I take full accountability of what happened that day. And I am very, I changed my life all the way around. I don't hang around the same people. I have a child now. I'm in school. Everything around me is positive now.
Did you have a child then on March 30th?
Yeah.
You didn't have any? Were you pregnant then?
No, I got pregnant after.
Okay. Go ahead.
And it was out in a kind of a hard situation, but I take full accountability of everything that happened that day. I wish everything was different, and I wish I could take it back, but it's you can't take it back. It happened, and I take accountability of what happened.
What caused you to act this way?
I want to say I was just at a breaking point, really, to the point where it was so much that happened to me, with these people. So it's a breaking point thing. And I was kind of in the fear of my life, and they probably was in the fear of their life as well, too.
How were you in the fear of your life? Can you explain that? Because only one person was shot more than once, right?
At the time,
It was you doing the shooting.
When it was going on, before the shooting happened, she was kind of in her vehicle trying to run me over. It was a thing like that. So I was basically not defending myself, but at the same time, trying to protect myself and who I was with. And basically, I guess she was trying to protect herself and who she was with.
Okay. The police came out and investigated this, didn't they?
Mm-hmm.
Okay. So after their investigation, did they charge the other people with attempting to harm you in some way, attempting to kill you, or attempting to assault you with their car? No? Is that no?
No.
You have to speak out.
No, sir.
Why do you think that? Or did the police fail in their job, or do you think they investigated this thoroughly?
In my opinion,
Mm-hmm.
I really don't think that it was, because when they called me, I was actually I was out of town when they called me. But I told them when I came, when I was coming back, and they were supposed to come out and fully investigate with me to take my side on what happened that day, and they didn't.
Well, they investigated it, and they did not elect to file charges against the other people who you say were attempting to harm or kill you with a car.
Correct.
And you were defending yourself. Self-defense. That's what it seems that you're saying here. You're not admitting. You're saying that they were trying to harm you, and you were defending yourself by protecting yourself with a firearm, and shot somebody 3 times, right?
Yes, sir.
The right shoulder blade, left ankle, left forearm, and upper lip. 4 times.
Let's pause. She claimed self-defense, but the police didn't charge the other party. That's huge. If no threat was officially recognized, this entire defense starts to unravel. This moment right here, it's where reality hits hard.